As you can see in the first slide, this is how I've broken it down. One, we're going to take a quick flyover of the rulemaking process, how the Texas disciplinary rules of conduct are amended and changed, and then we're going to look at what the current rules for lawyer advertising are, then the proposed changes. You have in front of you a printout of the clean version of the proposed rules on advertising. The Texas Bar Journal published two versions, the red line version, which is confusing, and the clean version, which I want to call your attention to because that's much easier to follow. Now, later on in the presentation, I will go over what currently the rules are and what the structure of that is. So hopefully you can follow along with the clean version of the proposed rules and better identify some of the differences. Generally speaking, what I found to be in the proposed rules is substantially similar, with a lot of tidying up of a bunch of specific instructions and rules on specific things, but the general feel and the general intent of the rules are the same. Let me qualify that by saying the purpose of this CLE is less instructive in telling you what to do and not do, and more instructive in showing you what's going on right now with the Committee on Disciplinary Rules and Referenda and how you can participate in this rulemaking process. So to tidy all that up in one short, succinct theme statement, this CLE is about your input and participation in the rulemaking process. So if you don't agree with anything that I have with something I have to say, that's great. We want to hear about it. As a local bar association, I'm of the opinion that, it's something that we should discuss together because it affects all of us, and we are all united by our geography and by the practice of law and these issues. So we are gathering your input on our hnba.org website, and I'll show you a link for that later where you can participate in a survey that we've put up. If you've already participated, I know some of you here today have. Thank you for doing that. It's a very short survey. It doesn't address every single issue in here, but the Committee on Disciplinary Rules and Referenda, the CDRR, is also accepting feedback, and they're looking for it. They are receiving it. They have been receiving it, and so that's why one of the last things I'll go over is what the comments have been so far. Okay, I'm really not going to take any questions because I have lots of content to go through. Hopefully there will be some time at the end, but if you have further questions, I'm happy to stay afterwards. If you have additional comments, save it for the online form at the hnba.org website or the CDRR website. Okay, first thing is to get my clicker working. And my clicker... There we go. Okay. Beginning of the rulemaking process starts with the government code that establishes the state bar in the first place. That's Chapter 81 of the government code. Specifically, Subchapter E1 that establishes the Committee on Disciplinary Rules and Referenda. And these are our current members of the committee. They meet monthly. They record their minutes. They make them available on the Texas Bar website. They have video from their quarterly meeting, which they held in January, which they accepted comments on this topic. So their duties include reviewing the disciplinary rules of professional conduct and suggesting changes. And so that's why this issue has come up. The general process is outlined in front of you. We are currently on step 3 and 4. They've had their public hearing in January. They are continuing to accept comments from the members of the bar, from the public even, through March 1st. Okay, so we're trying to get you this information under the gun. I'm glad you're here. Thank you for coming and learning about this issue. If you have a comment to make, please get it into the committee before the 1st. For anyone who's not familiar with the rest of the rulemaking process, if it gets passed by the committee, then it goes to the state bar directors. If the state bar directors approve it, they petition the Supreme Court. The Supreme Court then creates the referenda for us as general members of the bar to vote on. The general members of the bar approve it. Then it goes back to final approval by the Supreme Court. Again, quick flyby. If you have any questions, say them. Okay, current rules. Again, this is for a brief flyover of what is currently in the rules so that we can I can help you identify some ways in which the proposed rules compare with the old rules. Okay, so the first rule, 7.01, has to do with names. And this is one of the main hot button topics for the proposed rules. Old rules do not allow trade names, and there are rationales for that, which I'll get into later. So I'm sure you all have opinions on it. Save it for later. The names allow for deceased and retired partners for the firm to continue to bear those names as long as it's not misleading, right? Main names are also okay. You can't say that you're a partner if you're not. And if a firm is operating in multiple states, then they have to show which states their attorneys are licensed. Okay, 7.02, communications. Bottom line is nothing false or misleading. 7.02 currently makes specific examples of what is considered misleading. Omitting facts is misleading when it changes the whole idea. Referring to past results is based on one commenter's research is almost always misleading. At least that was their rationale. But the current rules do list what requirements there are for citing past examples in your advertisements so that they're not misleading. Current rule doesn't allow unsubstantiated comparisons against other lawyers. And offering services in a practice area where you're not competent and advertising for cases which you're likely going to refer somewhere else. Those are identified as things that are misleading. 703, specifically solicitations and payments. Obviously, the rule that most people are familiar with is you're not allowed to solicit in person, over the telephone, or electronically for employment arising out of a particular occurrence or series of events, right? This is the ambulance chasing, right? If you see someone who's injured, you can't walk up to them and say, do you have a lawyer? Do you need a lawyer? Let me be your lawyer. This is to discourage the overbearing and potentially misleading and practices that some attorneys have done in the past, and to protect the public from that kind of behavior by attorneys. Okay, there are some, qualifiers. If it's a family member, you can solicit your family members all you want. Good luck with that. Former clients, and it identifies pecuniary gain as a significant motive that is not good when soliciting. They're trying to discourage coercion, duress, fraud, harassment. They don't want you paying for referrals, having or offering anything of value to your prospective clients. Again, don't want to get into the nitty-gritty details. This is just a quick review of what the rules currently are. 704, public media ads. One lawyer has to be designated as the one responsible. So if the advertisement is found to be misleading or issues, that's the attorney who's the fall person, who takes the fall for, and who's responsible for making sure that the advertisement complies, and so the ad review committee and the potential grievance has an attorney to hold responsible. One significant rule that's come up with the changes is saying whether or not you're specialized and how there are specific language you have to use if you are board certified by the Texas Board of Legal Specialization. Advertisements must have a clear indication that it is an advertisement. It has to say in big letters that it's an advertisement. Another issue is not having actors portray attorneys or clients is another issue. Requirements for using a co-op or an association that generates leads. So it's where a bunch of attorneys get together and they, or there's a corporation that generates leads for attorneys. There are strict rules about when that's okay and it's not okay. Quick question.
Regarding the cooperative, are you talking about like a private lawyer referral service that makes
The rules do mention what referral services are okay. The old rules specifically mention that, and we'll get to what the new rules focus on. If you look in your handout, you'll be able to see whether or not it specifically mentions referral services. And off the top of my head, I can't tell you. Rule 705, written and electronic ads, nothing, again, false or misleading. It has to say advertisement. It can't resemble pleadings or other legal documents. Again, that would be significantly misleading if you send someone something that looks like a legal document that they have to respond to in order to get them to pay you to be their attorney. Ads must be reviewed and approved by the attorney who's going to be responsible for them. You can't just have some advertising company or a paralegal or assistant create your letters and send them out and say, it wasn't me, it was my attorney or my paralegal or my advertising company. They're the ones who did it. You can't pass the buck on that. Exceptions, again, to family, clients, current clients or former clients, motivated by pecuniary gain and in response to a particular occurrence or series of events. Rule 6, prohibited employment. Any employment you get in violations of these rules, you have to turn away, or you have to terminate that employment. 707, the filing requirements, which apply to all these communications, the advertisements, they have to be approved, they have to be submitted to the advertising review committee no later than the first dissemination. So if it's a mailer, you have to file the application and the document itself with the ad review committee at the same time that you mail it out, or you can get pre-approval if you do 30 days before mailing it out. Exceptions for tombstone ads, if you're not familiar with that concept. This is the bare bones information, your name, your firm, address, contact information, even areas of practice is okay, but it specifically identifies what information that you can include without having to get pre-approval. So, that's a quick look at what the current rules are. The proposed changes came to the Committee on Disciplinary Rules and Referenda from the Ad Review Committee itself. And I think that's interesting because the Ad Review Committee are the ones who are directly involved with the advertisements. They're the ones in charge of making sure that the advertisements are approved, and if they are actionable by a grievance, they're the ones who send it to the Council for Disciplinary Stuff. Here's the Advertising Review Committee. It currently consists of 12 members. In their letter to the CDRR, they cite changes that they can make internally without any changes to the rules. One of the changes that they're implementing is a change in the tone of their rejection letters. So whenever you send a advertisement to get reviewed, instead of saying, make the changes within 10 days or else we'll file a grievance with you, they say they're changing their tone.
They're softening?
Yeah, to a more customer service approach. I'm pretty sure they can still refer it to the chief disciplinary officer to if it's a grievable offense, but they're changing their tone in the rejection letters. They're only going to review the homepage of the website because websites can be massive. My website probably has 100, 200 pages. For them to have to review all of that would be difficult. And they're also creating an online ad review portal to make it easy, so it's not all paper-based. All right? The changes that they are recommending that require approval through this process constitutes a pretty major overhaul. Instead of having the 7 individual rules, it will be cut down to 5 rules, and instead of a lot of redundant references to communications that are misleading, that's the first and foremost fundamental rule. It's going to specifically mention social media and allow the use of non-misleading trade names. Okay, and the source for their recommendation is the ABA model rules and the Virginia rules of professionalism. The core principles, this is my distillation and interpretation of what's happening, is a shift to focusing on, instead of enumerating everything that could possibly go wrong and all the possible bad conduct, focusing on the foundation principles of not doing anything to mislead the public. And again, there are differences of opinion on whether that's good or whether that opens up more potential for attorneys to weasel their way into doing things that are harmful to the public. Don't take unfair advantage of consumers. Ads will continue to be submitted for approval, except for exempt ads. So those are the bite-sized nuggets of what's going on with the proposed rules. Going into a little bit more detail, again, anything false or misleading would create an unjustified expectation of results, promising that you can get someone a whole bunch of money when you can't promise them that. Doing anything that's coercive puts them in duress, fraud, overreaching, intimidation, undue influence, deception. Another issue is the hidden cost of contingent fee cases, where someone thinks that their case isn't going to cost them anything up front, but in the fine print of their agreements with their attorneys, there are either hidden costs that they have to pay, or they have a misunderstanding of how the fees come off the top and the breakdown of dividing up the award. Some attorneys do advertise their fees, and again, they don't want any bait and switch with advertising one fee and then a client hiring an attorney, and then all of a sudden that fee's not available anymore. And they still don't want any solos like me pretending to be part of a firm when we're not. Okay, again, going back to not taking advantage of consumers, solicitation still would not be allowed in a particular event or occurrence, whether that's in person or electronically. I actually have an example of what I think would constitute an online solicitation.
Well, can I ask
Later. Sure, go ahead.
So, like, I have clients who, as soon as you file something, opposing sides getting all kinds of letters from attorneys that says, oh, we noticed that you've been sued. Why is that not a solicitation?
Okay. instead of getting into the weeds of whether or not that constitutes a solicitation, let me get through the rest of the content I have so that
That's okay.
the goal was to give you information so that you know where to look for resolving specific instances that you've seen. Does that make sense?
Yeah.
So I'm not trying to avoid questions, but like I said, we've got a lot of content in this presentation. So they still don't want, the new rules still would not allow paying for referrals, whether that's from another attorney or a referral service. You can pay for reasonable advertisements and for PR. You can participate in approved referral services, but you still can't accept any wrongfully gained employment. Still have to file ads. I think there's an issue that one attorney in particular had with the language not specifically saying you can get pre-approval by filing the 30 days before, but it is still appears to be the intent of the ad review committee to accept filings before dissemination so you can get pre-approval. Did that make sense? I think that was a little wordy. Let me rephrase so that it's clear. Under the new rules, it doesn't say you can get pre-approval, but the ad review committee should still be able to take filings to give you pre-approval. And you would still require, you still may be required by the ad review committee to provide additional information to substantiate your advertisements. In particular, I think the most common one is when you advertise testimonials or results, they're going to want to substantiate that with additional information. There will still be exemptions for tombstone ads, listing on a regularly published law list, sending out announcement cards, and again, sending information to existing and former clients. Okay, major hot button for this issue is trade names. And there are a lot of comments on both sides of the opinion, whether we should have trade names in our profession or we should not. But the proposed rules would allow them as long as they are not misleading. And again, specific examples of what would be considered misleading if the name implies a pro bono organization, but it's not. So if it says like clinic, a legal clinic in the name, that would suggest that that firm is offering pro bono services, and if they're not, that could be misleading. Implying governmental authority would be misleading, and using the names of non-lawyers would be misleading. Okay. One of the issues that has come up with this process is what is constitutionally acceptable as free speech versus what behavior can be prohibited by the law. One of the commenters cited the Bates case from 1977, and that was an attorney who, or it may have been more than one attorney, who started advertising when the rules in Arizona didn't allow advertising. And bottom line was the court says you have to allow some advertising as free speech. And the quote that I enjoyed out of it was, restraints on advertising are an ineffective way of deterring shoddy work. An attorney who is inclined to cut quality will do so regardless of the rule on advertising. But the bottom line of that case, again, was obviously there is a governmental interest in protecting lay people from deceptive practices by attorneys. But people also have a right to the information they need to choose a lawyer and hire them. The other case that was brought up was Friedman versus Rogers, which was a case involving a Texas rule against trade names in the optometry profession. And the quote I picked out of there says, "Because these ill-defined associations of trade names with price and quality information," meaning the price and quality information is in the name itself, like discount optometrist or super awesome great optometrist, that information in the name can be manipulated by the users of trade names. There is significant possibility that trade names will be used to mislead the public. And that's cited as support for why it would be constitutional, why it is constitutional for the bar and the Supreme Court and the legislature to prohibit trade names. So those are the legal issues. Here are some factual issues. There are businesses out there offering legal solutions without having attorneys as employees, without being law firms. I'm sure most of you have heard of LegalZoom. They offer automated forms as a legal solution. There are others out there, including Axiom, which advertises legal solutions, and they connect business clients with attorneys, but they're not actually a law firm. They advertising being able to get you a lawyer, and they do it in a way that makes it seem like they're the ones offering the legal solution, but it's really the attorneys that their customers hire that are doing the legal work. There's another one called Law Tigers. This one was brought up by a commenter who, raised this issue with the committee, and their advertisements are directed towards people involved in motorcycle accidents and how they generate leads for attorneys to take these motorcycle accident cases. Again, Law Tigers is not necessarily a law firm. I don't know enough about their structure to tell you whether or not this type of thing is okay under the current rules or under the new rules. It's just a fact that they're out there, okay? Another one is Rocket Lawyer. This one's out of California. Similar concept to Axiom, but a little bit more transparent, I think, in showing you, giving you options about which attorneys you can take, but they do also offer legal forms. So they're kind of a mix of LegalZoom and Axiom, I think, but they're out there and they're offering legal solutions to clients, and they're competing in this space. But they are not subject, the businesses themselves are not subject to the rules. Attorneys who serve clients that come from them are subject to the rules, but like LegalZoom, they don't hire attorneys. You can't call up LegalZoom and get an attorney. They have a referral service type system in place, but again, not subject to the rules. So that's just a few examples of what the market for legal services is like. Now, when I say a market for legal services, I know there is one position that a lot of attorneys have in saying the practice of law is not a business. And it should not be a business, is the opinion. Excuse me, let me get some water. There's another position that it has to be a business because you have to be able to make money and make a living, right? And so there are differing views on what that means and whether it should be promoted or discouraged, but those are the viewpoints that directly influence the way attorneys think about this issue. There's also a matter of taste, right? Because there are attorneys who are subject to this rule that other attorneys think don't reflect well on the profession. So it's not that these attorneys aren't following the rules, it's even though they are following the rules, there are other attorneys who are bothered by what they're doing with advertisements. And so here are a few examples of attorneys who have gotten a lot of attention from other attorneys as not being very tasteful in their advertisements. That's not my opinion. It's just an issue that has come up, even in the committee's discussion itself, in separating the issues of law, the issues of protecting consumers, and the issues of just what's your taste? What are the other attorneys' tastes? What are consumers' tastes? Because as the consumers speak for themselves in regards to these advertisements. So the first one is actually this attorney who advertised did appear at the January meeting for the Committee on Disciplinary Rules and Referenda and voiced his opinions. And his submission is also available on the CDRR's website.
It ain't pretty when you face a bad truck wreck. Bring it in your touching place early. Bring it on. I'm Jim Adler, the Texas Hammer. Go at them with Jim Adler, the tough mark.
Okay, so if you're not familiar with that one, I don't know where you've been. I was familiar with that one probably in middle school, to make you guys feel older. Here's another one that's more of my generation.
Can you step back? Thank you.
Brian Wilson, Texas Lawhawk. Brian Wilson, the Texas Lawhawk. Challenge of justice.
Okay, so again, my point in showing these is not to say whether or not they're okay under the rules, it's to illustrate the different issues that are involved. There's the constitutionality issue, there's the actual status of the market issue, and then there are the matters of taste issues.
There was
Okay.
a guy up in Wisconsin several years ago that dressed like a superhero. Did a series of ads.
So, again, I think it's important to identify the differences in these issues so that, one, we can determine if, for ourselves, in your opinions and your submissions to the committee, on whether a trade name is really just a matter of taste, or is it a matter of law, or is it a matter of helping the consumers or protecting the consumers? Because there are arguments on both sides. A trade name can help consumers identify legal services and legal options better, or it can be misleading, or it can do both. Okay? So again, my purpose is to engage you in the process and to get you thinking about the issue. And if you want to know my opinion on the matters, we can talk when I'm off camera. Okay, another issue that has come up directly from directors of the Texas Board of Legal Specialization. They came to the January meeting and they identified that the new rules removed language regarding what should be specifically said about whether or not a lawyer is specialized, and whether or not a lawyer can say that lawyer is specialized if their certification is from an entity that has not been accredited by the Texas Board of Legal Specialization. So under the new rules, the concern is dubious organizations can provide dubious certifications for attorneys to advertise, okay? And so that's one of the concerns, and what they requested is that we keep the existing language and just bring it over into the new rules. They didn't appear to me to have any issues with the other language that's there. They just didn't want that specific language that is currently found in 704B2 to be left out and to put consumers at greater risk of dubious certifications and specialization. Okay, other comments in general about advertising. Again, there was concern that the new rules don't say anything about pre-approval, so does that mean we can't get pre-approval? Some comments say no advertising should be allowed at all, that we were better off when advertising was not a thing. People wanted some clarification on what is or what isn't considered a solicitation. Again, that goes to whether or not this idea of stating general rules and broad principles is going to be effective in discouraging and giving an action to attorneys who maybe flirt a little bit too close to this line. Okay. Another issue that's come up, some attorneys don't want actors to be able to portray clients and attorneys, and I believe under the new rules it would allow that, or at least it doesn't specifically say actors aren't allowed. People don't want advertisements by attorneys to include unsubstantiated claims of superiority or being able to get a better result than other attorneys. Also, other concerns include one attorney who responded in the comments cited the efforts that they went through to get the rules passed in the first place and research they conducted decades ago regarding the public's perception of attorney advertisements that include past results. And the argument is that talking about past results is almost always misleading as a blanket statement. So again, that argument was made. If you want to go research that argument for yourself, the materials are available on the CDR website. Another question that came up was, is it okay to take a client to lunch? Is that offering something of value to a client, or is it nominal? Okay. So another instance of, under a general rule with a broad principle, that's not, some attorneys don't know what to do with that. They don't know if it could be misconstrued as giving something of value. So I get the feeling that there are attorneys on two sides. Attorneys who want to get away with anything, and attorneys who are afraid of putting one toe over the line. And so, you know, both concerns are being raised with the way these rules are changing, in that, you know, if I'm an attorney who doesn't want to put one toe over the line, I'm going to be scared to do anything. Whereas if I'm an attorney who is willing to get away with anything, I'm going to use it to my advantage and say, you know, I wasn't doing anything misleading, and the new rules are broader than the old rules. And so if the new rules are broader than the old rules, then that means all the specific examples and things delineated in the old rules are now okay to do, is one concern being raised. Another concern was raised when, in the context of talking about other attorneys, when either giving a recommendation or withholding a recommendation or recommending somebody not go to a particular attorney. They wanted a little bit more clarification on what's okay to say about other attorneys without risking getting in trouble. Because there can be valid concerns about, you know, someone say, oh yeah, I'm going to go to this attorney, and you say, well, I wouldn't, and the client wants to know, well, why wouldn't you? And the attorney feels like it would be in the client's best interest to know certain information, but at the same time, the attorney doesn't want to get in trouble for defaming or saying something that can't be substantiated. So, comments in favor of trade names. Let me check my time.
You're good.
Okay. I'm trying to get it through it quickly so we can have time at the end for discussion for all these issues that I see triggering responses in the live audience here. Okay, so one of the arguments in favor of trade names is that 47 other states allow them, and that Texas is only one of 3 that does not allow them. The other 2 being New York and Ohio, I believe. And so there are arguments and interests on both sides of that. One, we should be different from those other states. One, we should be the same as the other states. Arguments that say including information about a practice area can be a good thing for clients and consumers who are searching for legal solutions. Because there are people out there searching for legal solutions, and there are people out there who don't know they need legal solutions. And so the argument in favor of trade names is it makes it easier to find. Because people don't, when they need an attorney, they can't think of an attorney name off the top of their head and plug it into a search engine. The counter argument to that is, well, just because you got to the trade name first, doesn't mean that you're better than any other attorney in that practice area. Okay? Another argument is that common surnames create ambiguity. If your last name is Smith or if your last name is Jones, searching for an attorney named Smith, you're going to yield a lot more results in your search engine than you are searching for someone with a less common name. As someone with a fairly common name and also a fairly large corporation with that name, people plug in Freeman to a search engine, they're going to come up with a cryptozoologist, an actor, Indiana Jones and the Raiders of the Lost Ark, as an aside, I was watching that with my daughter the other day, and she's like, "You were in this movie?" And I was like, "No, that movie was made before I was born." Anyway, issue of common surnames. It also applies to difficult surnames that are considered difficult to the public. If it has a difficult spelling, if it has a difficult pronunciation,
Polish names.
so the argument in favor is that it makes it easier for consumers to find your practice because they don't have to remember how to spell your difficult name. Okay, arguments against trade names. Again, coming down to reflecting poorly on the profession. You don't want 1-800-lawyers because it sounds like, anybody can be a lawyer and you can go get quality legal, or you can get legal solutions from 1-800-lawyers, or, Attorneys R Us.
It already exists, probably.
So the other argument against is you don't want to mislead the public because you can say, hotshot litigators, and maybe those attorneys aren't really that good, right? But maybe they are. So, arguments, and counter-arguments on both sides, which, surprise, surprise, with a body of attorneys, you're going to get a lot of arguments. So, what can you do with your comments? Go directly to the State Bar website. I have a shortened link for you here because the full link directly to the URL for this website was probably like 100 characters long. So this short link is just type it into your browser, bit.ly/txbarcdrr. Believe it or not, that's shorter than what would have been up there if I just copied and pasted it from the browser. That's their contact page. The short link will redirect you to that contact page where you can submit your comments directly to the committee, let them know how you feel. They want feedback. They've been asking for feedback. They've been trying to get the word out because ultimately it's going to come to us for a vote. And if they pass something that's ultimately going to fail, they're going to want to know what the general consensus is. Or you can comment to our bar association, and we can aggregate our comments as a local bar so that all of them go to the committee together. If you go to the announcement for today's CLE, there's the form built directly into the page, and the link for that is bit.ly/HNBA02-2019. I'm not going to guarantee that your comments will get to the CDRR. I'm not going to, but as a local bar, I feel like we should be able to talk about these things together and get a feel for what our local bar association, how our local bar association feels about these rules, because they directly impact us. I mean, this is one of the rules where it affects ultimately how we can serve our clients. Okay? I'll go ahead and take questions and comments at this time, seeing that we were able to get through quite a bit.
The last 10 years, one particular thing I've noticed among baby attorneys, new attorneys, is using their name and associates when they're sole practitioners. I've seen that a lot.
Oh, yeah.
And to me, that's very deceptive.
That's another thing that's come up in the comments. Some people saying the name of the attorney and associates without having any associates, or saying blank law firm is inherently misleading. And there are some attorneys who say it's
Allows
not.
for growth.
What?
That-
Allows for growth.
That it allows for growth. That's the counter
You don't want
argument.
to change your stationery.
And that's another point with getting approval of advertisements with the ad review committee. Anytime anything changes about your firm, that's another submission to the ad review committee. Woody, you had something?
Yeah, a couple things. I'll try them one at a time and let other questions come in here. How do you perceive these advertising changes and limitations to impact upon the real world of advertising from this standpoint? You've got Facebook, you've got all these social media, you've got national television advertising. So what happens with respect to these rules when some corporate entity, some legitimate corporation in Virginia or some other state, does this national advertising? You call the 800 number and they ship you to an attorney in Houston, Texas. Is that violated, or is that consistent with it, or it's a different world in a sense today than 20 years ago?
Woody, I couldn't have paid you to make a better question.
I didn't accept the check.
Woody's question was, what do the changes ultimately mean, or what if they're not changed, right? Because we're still in the middle of the process. The committee could say, no, let's go back to the drawing board and stick with the old rules, or it could go all the way up to the Supreme Court, and the Supreme Court could say, no, we're not going to change the rules. For me, and this is where I'm going to get personal, and I'm going to leave it to you, even though I'm still on camera, I'm willing to take that risk, because you know, and I've said it several times, that my purpose in this presentation isn't to persuade you one way or the other, but to get you engaged in the process and thinking about, you know, what's in your interest and what's in your client's interests. I'm going to start with an example of what could possibly be considered a solicitation online. And I found this on Facebook about a year ago. And it was a lady who was telling people about her accident, that she got hit by a driver, and she was, you know, she wasn't raising legal issues, she was informing the public about what happened, and, you know, people were commiserating with her. And I see this comment from someone saying, essentially, you've got a good case, call me. And I started feeling the, you know, the sliminess of that type of approach. Again, for me, I wouldn't do that, because to me that smacks of solicitation, because it's a particular occurrence of events. She had a picture of herself and a neck brace. You can't tell, I covered up her picture for her privacy, even though it's posted on Facebook. But to also bring the point that this is probably not what we want to see. This is probably what's going to reflect poorly on our profession. This is what some might consider ambulance chasing. And so my response directly to this attorney in that same comment section was, dear so-and-so, I invite you to come to our next CLE, which will be an ethics presentation on the Texas disciplinary rules of professional conduct. And I'm sure we'll talk about proper engagement of potential clients. Could I have reported this person to Chief Disciplinary Counsel? I could have. Should I have? Maybe I should have. Maybe I am now in violation. Maybe, I don't know. I'm not an expert on ethics, but that's not why I bring it up. And, you know, it is a risk for me, because what if I'm reported for, and now have I just implicated you all in, you see where it goes? You see, and anyway, I felt like I took the right approach. One, because his post was not that long. And I didn't feel like it was necessarily coercive or harassing or undue. I felt like he was just putting his name out there for her consideration. But at the same time, I felt like it was skirting a line, and that's why I invited him to come out. I see hands coming up. Let's start with you, Bowie.
I was not that purported lawyer. But would it have changed your mind if they had asked for recommendations for attorneys, or who can help me, and then they did that? Would that have been okay?
Excellent question. And I can't give you an answer to that.
You can tell me how you would feel about it.
But the question is, for anyone on the recording who can't hear, is if this particular person asked for recommendations, would it be solicitation to respond to that? Based on the new rules, well, based on the old rule, the current rules actually, if the communication is requested it's okay. So if somebody calls you up and says, can I get some information from you, right? Well, the difference is, and this is where the old rules kind of fall short because they were written a long time ago before Facebook, and they've been trying to keep up, but it's hard to keep up with things like Facebook and Twitter and all those other social media things where it's happening instantly. And lawyers are having to make split-second ethical decisions, and they might not intend to violate any ethics rules, but maybe it could be construed as an ethics violation, right? So, again, I think if somebody requested information, you know, it would fall under that exception. But under the new rules, you'd have to look at that closely for yourselves. And, you know, if that's a comment you want to submit to our local bar or to the CDRR, yeah, please bring it up because and this is what I would say argues in favor of the broader rules is if you try to go the delineated route of naming every possible thing you could do wrong ethically, you're never going to keep up. But if you identify the fundamental issues of don't do anything harassing, don't do anything, don't exercise any undue influence or misleading, you know, I think that and we as a profession can informally improve the perception. Because with this comment that I made on Facebook, there was at least one subsequent comment from what I think is a layperson who thought my comment was hilarious, right? So not only did the public see this lawyer leaving his or her phone number for this person to contact him, they saw another attorney saying, there are standards in the legal industry for contacting potential clients.
But don't you think him saying, you've got a good case, just from that post, I mean, that kind of, you know, maybe if he'd have said, you might have a good case, or I need more information to evaluate it, I'd be happy to talk to you about it. But just saying, you've got a good case from, you know, the neck race, yeah, that's great.
Yeah.
I can get you a lot of money.
That's a great point in identifying what little nuances can attorneys do intentionally or even not intentionally. And the thing with intent is how do you prove it? And when you have a body of professionals who have firsthand experience with the difficulties of proving intent.
But let's take, just allow me to just.
Yeah, please.
Suppose we take the conspiracy one step further. Suppose he put her up to them and told her, look, take this picture and I'll comment on it and we'll get some feedback.
So the question ultimately arises with the rulemaking process is, can that be enforced? Or will including a rule protect the public from that type of conduct?
Yeah.
Sorry.
There's a whole industry out there about where lawyers send direct mail where they get a listing of addresses of people charged with a crime, misdemeanors, and they come in a basket this big of letters that they ship out to with letters and the letterhead and everything.
Yeah.
And I don't know what they say, but that's there. And then they follow accident reports whenever they become available to send out a letter saying I'm a PI lawyer.
So.
And even further, I'm known for, I mean, it's not a big secret, that people actually pay for cases. Lawyers pay for cases.
Oh, all the time.
So we have examples of violations under the current rules, right? And, you know, practically speaking, any rule change isn't going to stop bad actors from doing what they want to do.
Like when he says you've got a good case, I mean, that pales in comparison to the guy that will say, here's $1,500. We think that's what we think is the case, and there's more to come.
So we have a broad range of things that are considered ethical, less ethical, and most unethical. But for me, part of the solution is not just saying what's okay to do and what's not okay to do. It's doing our part to promote professionalism outside of the rules. And one of the best examples I can think of in doing that are attorneys who create their own content that's informative and establishes their authority to talk on a subject matter. Traditionally, that was done by writing legal articles, giving CLEs, things like that. We are no longer limited by what journals we can get published in and what journals we can't get published in. We can publish ourselves. Now, again, there are arguments on both sides that if attorneys publish themselves, it's not peer-reviewed, and it can still mislead the public. Well, in addition to this example of what I think is in poor taste, I have examples of other attorneys who I think are doing the right thing in good taste and who are doing it well. And the mechanisms in place that we have with social media can be used for good, not just for bad. So regardless of how the rules turn out, there are things that we can do to promote professionalism and promote our experience and knowledge in an area and support lawyers around us who are doing well. So it's not just us doing it ourselves. And so here is a slide that shows attorneys that I have seen videos of informative content talking about what the law is and how clients can handle situations without doing anything overbearing or anything that would be considered unethical, but are accomplishing two things. One, they're getting information to lay people who sometimes don't even know that they're facing a legal issue. And two, they're elevating the profession by showing their expertise. I can't necessarily say expertise, but they can't say that they're certified necessarily. So, I mean, maybe some of them can, but self-published content can promote professionalism. And we can help it, and we can hinder those who we think aren't being professional. Just like in the previous slide where I suggested to another attorney that maybe there's a better way to approach it. We can engage with other attorneys who are self-publishing, and so that lay people can see that we are self-governing, not just in the formal rulemaking process, but we can help keep each other in check through engaging in online content. One final thought, in the event that trade names do become available to the practice, again, I'm not saying it should or shouldn't, I'll turn my mic off before I do that. As a business attorney, part of my practice is advising clients on how to name their businesses. And this is an infographic that I use to help them make decisions and what the considerations are involved. These are not legal considerations in naming a business. These are marketing considerations. Lawyers have never had to think about this before, and if these rules pass, this is at least worth your consideration in, should I change my name? Should I change the name of my firm, or should I not? Because if the rule passes, the option is going to become available. And even if it doesn't, we're still going to have to compete. So the three main considerations that I have found in naming a business start with easy to locate. An example I use for that is 1-800-Flowers. That's easy to locate. The name is the contact information. So if you can remember the name 1-800-Flowers, you know how to get flowers, right? Consideration for a strong brand is something that you would not confuse with any other brand, like Xerox. That's an arbitrary word, it's a strong trademark, and trademark arguments aside and the potential loss of their trademark aside, it's an arbitrary word that everyone associates with a copy machine, right? And then there's a strong impression. Names that create a strong impression in the hearer's mind of a particular quality or result, which is, the main argument against that the people who are against trade names have a concern with anyone being able to come up with a name that suggests a particular quality of service and creating a strong impression just by having a name. But those are the marketing considerations that we can either avoid by saying the rule shouldn't be passed, or that we can adopt and use to our client's benefit. If you really think you are the best litigator in Northwest Houston, now the Ad Review Committee might not let you call your firm best Northwest Houston litigators, but if you're going to compete, and if that makes business sense for you and your firm, don't write it off. Or if it makes more professional sense for you to maintain an image with your clients that shows, we're just going to stick with the name of our partners, then you advocate for that. The end of my part of the presentation. We'll take any last-minute comments, questions, tomatoes, cabbage.